Like the record reflect, we are back in session. Parties and counsel are present. Our jurors are not yet present. Counsel indicated you wanted to be heard on something before we began closing statements.
Yes, Your Honor. I was informed by our mitigation specialist that she came in contact accidentally with a juror at a supermarket, and she's here to explain just what happened, just so it's clear on the record.
Okay.
Just briefly.
I was going up Lagonia, stopped at the Stater Brothers. Lagonia is the only way in and out of the mountains, and went inside, picked up groceries. At that time, their credit card and ATM went down. So they were having everybody stand in line. They were unloading your groceries, and then you would go stand in line at the U.S. Bank ATM to get cash. I happened to be there when the manager said, let's start spreading the word, we're not even going to try anymore to use it. So they asked us to turn around and tell the people behind us what was going on. And I saw several people. One lady looked familiar. I said my piece, and then later on I realized it was one of the jurors.
Okay. Not a problem. But I appreciate you bringing it to court's attention so it's clear what did happen and what did not happen, and won't be an issue later. Thank you.
Thank you.
Thank you.
Okay, we ready?
Yes.
Okay, we can go ahead and bring our jurors in. Morning. The record reflects we are back in session. Parties and counsel are present. All members of our jury and our alternates are present. And Mr. Moline, you may give the defense closing statement.
Thank you.
Your portion of it.
Thank you. Good morning, ladies and gentlemen. I'm not going to sit here and pretend that we're not disappointed in the verdict. We are. And to say that we're just disappointed would be an understatement. But having said that, we accept it. We have to. That's our system. And contrary to what you heard yesterday, we respect your work in this case because we know how long it's been, what you've had to go through. I can't even imagine how it would be to sit there for that many months having to deal with all the things you had to deal with, not only in the courtroom, but at home as well. To balance being here and doing your job, and you were all diligent, and so in that respect, we appreciate it. But we can disagree. It doesn't mean I don't respect you. It doesn't mean that I don't appreciate you, but we can disagree. Okay. And because we can disagree, there is this concept called lingering doubt. But lingering doubt isn't just there to say you got it wrong or you are mistaken. Lingering doubt is a concept that is used because of the nature of trials and the nature of deliberations. For example, when you deliberate on the question of guilt, it's a collaborative effort. And whenever there's a collaborative effort, some people may be more assertive and some people may not be. And some people may have a personality that says, I'm afraid to speak out, or I may not be as smart as them, or they sure as heck know what they're talking about, I don't want to say anything. So people sometimes in a collaborative effort remain quiet, but they also have their own individual opinion. And so lingering doubt allows those folks the opportunity to be heard in their own way, because lingering doubt is an individual decision. When you go back there now, it's different. It's not a collaborative effort. You don't have to ask people what the evidence was. It's a vote. You don't have to tell anybody. Nobody has to know. And you can express your opinion that way. From the very beginning, ladies and gentlemen, from the very beginning, even in voir dire, we talked to you about doubt and reasonable doubt at that time. But from the very beginning, this case screamed doubt. After all, San Diego was involved for 3.5 years, and there was no progress. San Bernardino was involved for almost a year. So, of course, nobody knew any answers. Nobody had answers to the fundamental questions in this case. I told you in voir dire, you probably don't remember it, but I told you that my biggest fear in this case was the human emotion part of it. That when you have a family that is killed in the brutal way that this family was killed, it's going to be very difficult to set that aside and say, this family doesn't deserve some type of closure, some type of justice. That pull on everybody to somehow make it right for them. Finally, after so long, we knew that was going to be a strong pull. Of course, you have presumption of innocence and all of that, but we're human beings too. So my biggest fear was, gosh, can they forget that? Can they forget their human nature to bring closure to this family? Lingering doubt gives you, the individual, the ability to make a decision without consultation from fellow jurors. It allows you to make a decision to respect the sanctity of life, because this decision is not based on revenge. I heard what counsel had to say yesterday, and their anger is justified. Their anger about this family is justified. But that's not the law. The law isn't revenge. The mitigating factor that I'm talking to you about today is, of course, lingering doubt. Doubt is unanswered questions. That's what it is. When you don't know the answer to a question, you have to have doubt. And this case is filled with unanswered questions. It's the same unanswered questions that existed when this family disappeared in February of 2010. And I would submit to you, ladies and gentlemen, we're no closer today to finding out what happened than we were in February of 2010. For example, where did this crime happen? Where? When did it happen? And how did it happen? Who was in the house making checks at 8:05 p.m.? Not checks, but a check alignment page at between 7:55 and 8:05 p.m. on February 4th. Who made a call from Joseph's telephone at 8:28 p.m. from Fallbrook? Who drove the car to San Ysidro, the trooper? And who do these three allele lists belong to? Who are they? There's certainly enough characteristics there for a human being. And they could be run, Dr. Perlin told you, he put it in CODIS format. It would take 1 to 3 minutes to run. And if those results, those allele lists are just nothing, then why not just run them? Why not just run them and see what it is? After all, this is touch DNA on the white cord.
That's the court's previous order.
Overruled.
The white cord that bound Joseph. Why would someone's DNA be on that? Wouldn't that person have something to explain? Who was in the house on February 8th between 2 and 4 a.m.? These are all unanswered questions. The where, the when, and the how. That's the meat and potatoes of any crime. So in this case, the where, we thought, the theory from the very beginning for the last 4 years was they were killed in the house. That's what we prepared our defense on, and that's what the investigators said. You heard Detective Steer say, There was no evidence of it, but that's what he believed. But they went back and forth. They teased you with, it happened on the 4th, with statements such as, Mr. Merritt went off the grid, given him enough time to go clean up the crime scene. They're referring to the house. Fresh paint in the house. Teasing you again that this crime happened in the house. But no evidence of it. Where did this happen? Was it in the house? Or was it somewhere else? Were they abducted? Were they abducted on the 4th? Or were they abducted on the 5th in the early morning hours where there was breakfast food out? All of these unanswered questions change the timeline. So for the defense, it's important to know what they're alleging so that we can say, hey, wait a minute, Mr. Merritt was there, or he was here. Dugal, back in San Diego in 2010, indicated that there was no evidence, he said it on the stand, no evidence that a crime had been committed in that house. A crime, not just murder, but a crime. Abduction, anything. And he got a search warrant on the 19th of February. And he did a big search in that house. He told you about it, with his homicide team that sat at the table that the prosecutors later came up with blood stains, or supposed blood stains, or something that looked like blood stains. And they all missed it. They had cadaver dogs. They did this because that was the working theory of the prosecution, that this happened in the house. When did it happen? On February 4th, we have the Mitchley video at 7:47. What does it mean? For 3 years, the vehicle was thought to be the trooper. And then San Bernardino comes along and says, wait a minute, it's not the trooper, it's another vehicle. And soon they locked horns on Mr. Merritt's vehicle. But that's anything but clear. February 6th. What happened on February 6th in the desert? Initially, the theory was he buried the bodies on the 6th. That's what San Bernardino alleged, that Mr. Merritt buried the bodies on the 6th. But that changed when Bowles took the stand. It changed in mid-trial. Because the records that Agent Bowles reviewed, the call data records, and the way he changed his testimony based on his new training. He went back east and got training, CAS training. And it's the beginning call that provides location data information, not the ending. He had to change everything. Those changes, as you saw, changed the nature of the whereabouts of Mr. Merritt and where he was pinging from, and whether or not he was mobile. And, of course, the prosecutors heard this. So no longer is necessary that he's burying the bodies on the 6th. And how? How did this crime occur? Was it one person? Was it two people? The theory that the prosecutors have gone with since the beginning was it was one person. It was Mr. Merritt. And he killed him in the house, and he loaded up the bodies in his truck and then buried him on the 6th. Did anyone ask how this would be possible for one person to do? Did anyone ask in the jury room, wait a minute, there's two different vehicles.
Proper argument.
Overruled.
There's two different size tracks, 73 inches and 76 inches. So how is it that, and that's their measurements. Actually, Mr. Licio said it was 71.5 inches. That doesn't match Mr. Merritt's truck. So those are two different measurements. There's not one single shred, speck, molecule, you name it, of evidence, blood or otherwise, that ties Mr. Merritt to this crime. Not one. That's the state of the evidence in February of 2010, and that's the state of the evidence today. So, the case took on a different form. So when we heard the closing argument from the prosecutors, we heard this. Oops.
I'm trying to help. Let me help.
Oh, you're on it?
I'm trying to.
Okay.
It does not require us to prove where. It does not require us to prove when. And it does not require us to prove how.
Oh, really? What have they been doing for the past 4 years? That's what we based our defense on, is combating the things that they said. But every time they put out a theory, we would provide a defense to it and block
Objection,
it.
assumes facts not in evidence.
Oh,
So they changed. And magically, after meeting with prosecutors, Dugal and Dennis Williams see what they believe is blood on a table. It's not, we don't know what that substance is. We don't know anything. But the who is always the easiest. Always. It's easy to say, you did it. And I can just build around that. That's easy. The meat and potatoes is the hard part. And they didn't give you anything. And you still have nothing on the meat and potatoes. And they admitted it in the closing statement that you just heard. Because he told you that because they don't have proof beyond a reasonable doubt on those issues. So that's why you heard that. You have the who. They pointed the finger at Mr. Merritt. And they called him a bunch of names. Greed. Shouting greed. Greed. Over and over again. And it's interesting to note that no matter how many times he shouted it, he didn't produce one witness, or they didn't produce one witness that said Mr. Merritt did a bad job on any job. They didn't produce one witness that said his work was poor, or that he didn't complete a job. And you saw how many jobs they were doing and the hundreds of thousands of dollars worth of business they were doing each year. But they shouted it. He's greedy, he steals, he does this and he does that. That's what you heard. And I talked about this in my closing. Under the authority of, for lack of a better word, the law, okay, the police, whom we all respect, law enforcement, okay, these prosecutors wear these little badges, and we all say, we want to, that's a great looking, that, they must have some authority, they must know something. If he's shouting it, the louder he's shouting it must be true. But he didn't produce any evidence that Mr. Merritt stole anything, did any bad work, or anything of that nature. He just shouted it. They shouted it. All the talk about Mr. Merritt pinging in the desert, his phone pinged in the desert, all on the 6th, because why is the 6th important? Why did it take on importance in this case? It took on importance because the theory was he buried the bodies on the 6th. So that became extremely important. They brought in an expert, Agent Bowles. And Agent Bowles testified that, under questioning from Mr. McGee, is it fair to say, with just the limited information that you have, that it would be too speculative to try to pinpoint a phone? Bowles, correct. Is it also fair to conclude that the only reasonable opinion or conclusion you could make from this data is that the cell phone was in the high desert area? Yes, I believe that's a fair assessment. Anything more detailed than that? No. I mean, you can get a general idea of where they were in the high desert, but it's still not very precise. That's what Agent Bowles said about the high desert. Agent Bowles never said that he's at the gravesite. Never said it. That's what he said, despite the claims of the prosecutors. So they changed. Agent Bowles said, based on the data showing in all the calls, in all the towers and sectors of those towers that were hit, is it a reasonable conclusion that between 10:46 and 1:30 that the cell phone, is it reasonable to say it was moving? Bowles, yes, I would say it's very reasonable to say that the cell phone moved, maybe not in a constant fashion, but periodically throughout that time period. And that's on the 6th, when they initially alleged that he was burying the bodies, digging the graves. So, you're left with these pings in the high desert. Okay. If the 6th is no longer the time that he buried the bodies, that's their theory, then my response to that is, who cares? What does it mean? What does it mean, and who cares if his cell phone pinged? And then they played you a clip of Mr. Merritt's statement where he says, he doesn't remember being in the high desert. And then they stop it right there, knowing that you guys have already heard the second sentence, which is, if I were in the high desert, I would be at my sister's or my brother's in Hesperia. My sister in Ora Grande or my brother in Hesperia. They leave out that, knowing that you guys have already heard it, but they leave it out when they want to make their point. That's called dirty pool. And the 6th doesn't mean anything anymore. Now, just to put it into context also, because it gets lost, when Mr. Merritt was asked those questions, why did you ping in the high desert? In February of 2010, they're asking him. On February 6th, by the way. They're asking him that question on October 22nd, 2014. More than, 4.5 years later? Now, Mr. Merritt has not talked to law enforcement since 2011. Or whatever the last date he was interviewed by San Diego, and then he's called in, and he goes voluntarily, and he answers all their questions. And then they ask him, on February 6th, why did you ping in the high desert? If somebody asked you where you were on this particular day, you would have a similar response. You're not going to say, I was here, 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 and here. Thank you. Check my phone records, it matches. No, you're not going to say that. That's not what we do. He did the best he could. Now, if Mr. Merritt would have said, oh, I was here, and I was there, and I was there, you'd have to give pause. You knew where you were on February 6th? It was a no-win situation to go into that interview so that these prosecutors could make hay out of anything he said. But they shout it from the rooftops. He lied. And then they play half the clip. He lied. And they say it loud and convincing with their badges. He lied. And we want justice for the family. So we say, okay, he lied. after the Bulls testimony, after that evolved, this is what we heard.
Oh, I'll do it. I'll have to play it.
I have to interpose an objection. This isn't evidence.
It's improper argument.
Overruled.
People's theory is that the bodies were buried on February 6th. Nobody has ever said that to you. Nobody has ever sat here and told you the bodies were buried on February 6th.
That was their closing argument. For us, and I don't know how it impacts you when you hear something like that, but for us, we've been working on this case for 4 years. So when we hear something like that, when their theory has been he buried the bodies on the 6th, and then we hear that, why would they do that?
Objection, improper argument assumes facts, not evidence. Improper vouching.
The objection sustained on that.
Then we have the truck issue. Okay? The theory is that Mr. Merritt drove there after 5:48. Remember, that's the call at 5:48, and he's in Rancho. He pings in Rancho at his house, and then, according to the prosecution theory, he drives down to Fallbrook. Okay. Tell us what you're accusing us of, and we'll deal with it. Because we know that Mr. Merritt didn't do this. So tell us what it is, bring it on, and we'll deal with it. That's their theory. Okay. Well, first we look at the video. And we notice that it's very difficult to see. Can't really see much. So we go back to the meeting in Rancho to see if we can backtrack. We know that the meeting occurred because Agent Bowles told us that they both pinged right in Rancho at the same location. And they were there for at least 2 hours at the same location. So either it's a super duper coincidence that they happened to be in the same location and didn't know each other were there, or they had a meeting. The meeting ends about 3 o'clock or so, maybe a little bit before that. At 3:03, there's a series of phone calls from 3:03 to 5:48 p.m. And Joseph is calling Chase. And during the first part of those calls, you can track Joseph actually driving south on the 15 until he gets to Fallbrook. But it's Joseph that's calling Chase 7 times. We know that Joseph gets home and is home for sure at least at 4:10 p.m. How do we know that? Because Joseph is on his home computer. If you recall, we had Exhibit 831, and I don't know if I have that to show you, but that was the Internet Explorer, the Internet Explorer visited sheets that Detective Schroeder testified about. And at 4:10, Joseph is on a website called Google SketchUp. And at the same time, he's on the phone with Chase. And it was a while ago, so I don't know if you remember the testimony of Brian LaRock, our expert on this issue. But we tried to coordinate the phone calls with the work on the computer. And Joseph was working on Google SketchUp, and he was calling Chase. Joseph was working on those, working on Google SketchUp until 5:01 p.m. That was the last entry that we saw in Exhibit 831. It was at 5:01 p.m. and the calls continued until 5:48 p.m. So while Joseph is working on Google SketchUp, after their meeting, he's not going home, and he's not saying, how do I get Chase removed from my business. How do I do this? No, he's working and he's talking to Chase. Now, this wasn't anything new. It shouldn't have been new to investigators or even the prosecutors, because Chase had mentioned all of this to Dugal in his February 17th meeting. He told Dugal, we met at Chick-fil-A to go over the Saudi Arabia project and the Paul Mitchell project. And there were some design changes that needed to be made. It was a very complicated waterfall. And he told Dugal about that. And if you listen to that interview, Chase says, you can hear they talk about it, and Chase tells Dugal, I brought the notes that we talked about, because Dugal had asked him to bring notes. And so that's why he brought the notes. And he brought the notes of his meeting. And that's what they discussed. And that's what is reflected in Joseph's work on the computer when he got home. 5:48 is the last call that Joseph makes to Chase that day. Next to the last call, I should say. So let's assume we're going to start our timeline at 5:48, because we know he's in Rancho. He pings off his home tower at that time at 5:48. And then, according to the prosecution, he heads down to Fallbrook to kill the family. Okay. So at 5:48, can we give a couple minutes to get into the vehicle, the truck or whatever, to go down to Fallbrook? Let's say he leaves at 5:50. Okay, we're talking about a Thursday afternoon. It's 70 miles according to Sergeant Steers, and you got to go travel south on the 15. I don't know if any of you know anything about the 15. I've ever been on the 15. I would suspect even Detective or Sergeant now Steers indicated that there's going to be traffic. So it's not going to be 70 miles at 60 miles an hour. It's going to be delays. So what time does that place Chase in Fallbrook if he left right at 5:50 and headed down there? Could he get there in an hour and 10 minutes like Sergeant Steers did with no traffic? I doubt it. Let's add 15 minutes. I think Sergeant Steers said that was a reasonable 15 minutes. Even 30 minutes was reasonable to assume given traffic. So that would get Chase in Fallbrook at 7:15 or 7:30. 7:15 or 7:30. Okay. Now there's a problem with that, because you remember Miss Mitchley in her video? Although the prosecution focused on 7:47 p.m., because that was the time that Miss Mitchley saw the vehicle pulling out of the driveway. And that's what she gave to the authorities. She gave them that time period. She saw that. But it came in blocks of 1 hour. Do you need to press it?
Are you going to play hers?
Yes.
Now, you said you looked through hours of footage before the tanker's call.
Yes.
And during that hours of footage, you just pulled out these two events when they gave you a time limit?
Yeah, I was looking at everything that I had, and then when you're going with other time frames, I focused on that.
And she went on.
Now we're looking at the desk code exhibit 417. There's two file names. See those?
Yes.
What I'll do is I will make these and I'll do it with the mouse because
again, it shows the February 3rd, 2010, 4 or 5 o'clock hour.
Yes.
And so the system records it in 1 hour blocks, and that's how they kind of designate the file's time frame.
It must when you pull it out.
And then the file number 2 is from February 4th, 2010, from 1901, which would be 7 o'clock hour, to 1959, up to the 8 o'clock hour. Would that be accurate?
Yes.
And those were the videos that we watched. But the video doesn't start at 7:47, ladies and gentlemen. The video starts at 7:01. And there's no car pulling into the driveway, backing in to the driveway, because remember, the vehicle that comes out at 7:47 comes out with the headlights first. But Miss Mitchell would have seen a vehicle. She watched it. Not only did she watch that hour before, but she watched hours and hours of it. There's no vehicle coming in, backing into the driveway. So what time, if Chase drove there and left his house at 5:50, he would have had to have got there before 7:01 to not be captured on the video. And that was just not possible. He could not have arrived there at that time, given the time of day, with no traffic whatsoever. Maybe he would have made it. But with Thursday at 5 p.m. or 5:30, 6 o'clock traffic, there's no way. And there's no vehicle, and his vehicle surely is not shown pulling into that driveway. So, and she watched hours and hours of it, before and after. And there's no indication that Chase's vehicle or any other vehicle backed in that fashion. But we do see a vehicle leaving at 7:47. If you go with the theory that they were killed in the house and loaded up, and then the vehicle pulls out at 7:47, how is that possible? Did anyone say or think, geez, how is that going to be possible for one person to do that? And then they told you, and they completely glossed over this, and rightfully so, if they're going to try to convince you, the fact that there's checks made at a check alignment page is accessed, sent to the print spooler from 7:05 to 8:05. 7:55 to 8:05. How is that possible if Chase left at 7:47? How is that possible, ladies and gentlemen? What was their theory on that? Did he double back? They're the ones that said it was Chase who did that. How? Did he drive back? He's not on the Mitchell video driving back. Did he park down the street and walk back and leave dead bodies in the truck? Or alive bodies? How did that happen? So who did that check activity, that check alignment page at 7:05 and 8:05 p.m.? Is it reasonable that it's Joseph? Because remember, even though we pointed it out, I'm sure it was lost over the yelling. This account, this customs account at QuickBooks, they had just started writing checks from that account using the custom account and using the custom account to account for it. The checks that that Chase wrote, those were among the first checks that were ever written on that account, using the custom account. It was the same bank account, but using the custom part of the business, the custom part of the QuickBooks. And their theory about the checks after the meeting on the 4th was that Chase did that at home in the clubhouse or some other place. So why would he double back and write checks on the home computer or try to write a check, and really it's a check alignment page? Why would he do that if he knows he can write the checks at home? Wouldn't a killer want to skedaddle and get the heck out of there? We heard a lot about the financial issues, and sometimes, and you know, quite frankly, I have to blame myself, because many times we allowed the prosecution to scream and yell all kinds of nonsense that wasn't true, without getting up and screaming and yelling right back at him. I mean, we did our fair share of that, but maybe we should have done more, because sometimes if you out-scream someone, they carry the day. For example, the checks that were written, that Chase wrote after their meeting on the 4th for the Saudi Arabia project and the Paul Mitchell project, prosecution's theory on those checks was that Chase stole that money, because there's no evidence that Joseph ever got any deposit. So why would he be writing checks on Saudi Arabia when there's no evidence that the Saudi Arabia money ever came in? Oops.
One more, I think.
Do you want me to do it?
Are you with this? Okay.
No indication that the defendant was there on the 2nd. That QuickBooks activity was again to Charles Merritt, deposit SA 1001, but this was a zero amount. Again, created, edited, to be printed, deleted. But then you had a second check created. Same memo line, deposit for SA 1001, this time with an amount, $24.95. Again, to the lowercase Charles Merritt, and again, created, printed, and deleted. What's more important is that check was actually cashed. That check was cashed by the defendant. What is interesting to note is there is no indication that the full deposits have been received for the Saudi Arabia project at this point, or
So that was February 5th, that check was generated. Wonder if we can blow this up. This is Joseph's bank account with EIP, and it shows that on, and I have it highlighted on the right. Is it possible to blow that up? No? Okay. It shows that on January 19th, January 22nd, it's kind of has this box, not highlighted, but there's a box around it. There's a wire transfer there on the bank statement. It's Exhibit 420. So on January 22nd, the $30,722 or $735 was received from Saudi Arabia, and that's the letter from the bank on the left, indicating that same amount, $30,735 received from Co-Cache. That's the Saudi Arabia deposit. So what Mr. Imes told you there in that argument was not true, okay? And I beg to differ with him. The interesting part about that scenario is not that the the deposit wasn't received, as Mr. Imes said. The interesting part about it is he knows that's not true. He knows it's not true. This is not new stuff, ladies and gentlemen. We've all been on the case for 4 years studying it. Okay? You haven't, but we have. So he knows when the $30,000 came in from Saudi Arabia. But he tells you that Chase steals the money because there's no evidence. He says there's no evidence that the deposit had been received. That's not true. But if he yells it and says it, and he has his pin, remember his pin, and he says, he stole it. There's no evidence that the deposit was received. That's untrue. Because when you receive the deposit, as you heard in the case, you got to start work. You got to start working on the projects. And that was the part of the meeting, and that's what Chase told DeGaulle when he met with him on the 4th. Same with Paul Mitchell. This is the check from Paul Mitchell. Again, very difficult to read, but on January 26th, it was deposited in EIP's bank account. Again, they had received, that's the $16,000 check they received from Paul Mitchell. So the way things stood, remember the memo on February 1st, or the email on February 1st? That's why Joseph lists Paul Mitchell and Saudi Arabia, because these are now pending credits for Chase, because they got the deposits, Chase is going to go do the work, and he's going to get paid the money. That's the way they did their business for 3 years prior. So the Paul Mitchell deposit had already been received, and now they got to go do the work. And that's why checks are generated. Not to steal them, to do the work. But they scream, steal, backdate, delete. Who cares? Who cares? The premise on the theft was that they hadn't even received the money from these deposits. And that's simply not true. I'm going to talk to you about, they made a note of this phone call to the bank that Joseph makes to the bank on the 4th. So there's a couple things I want to point out about the phone call to the bank. Joseph does call the bank. If we look at his phone records in Exhibit 442, on the right, which is February 4th, we see that Joseph calls the bank at 11:51. Okay? And that number there, again, very difficult to read, that we can't blow up, is 949-492-8090 on the right. Okay? That's the phone number. And that is Union Bank. That's Union Bank's number. So we know that Joseph called Union Bank on the 4th at 11:51. But the problem is, they argue to you that he discovered this theft and then dashed to Rancho to confront Chase about it. No. He's already on the road. Look at where he's at when he makes the call. He's in Temecula. He's already on the road. He's already up the 15. That's when he calls the bank. And who does he call? Well, who does that number belong to? We kind of know who it belongs to, because they found this card in the trooper when they processed it in San Ysidro, in San Diego. That is, looks like a financial service officer, Jerome Beelan. If there was a question about what the call was about, they could have brought him in. If there was anything nefarious about the call, if there was a complaint of theft or anything of that nature, there would have been a record of it. But this person is a financial service officer. Maybe it's somebody who opens accounts. And remember, Joseph gave $100 to Chase and a handwritten check to open an account. And that account was opened on the 3rd. Could that be the reason for the call? And Mr. Imes indicated in his closing argument initially that he had never called Union Bank before. And then he corrected himself after the lunch break. He he came back and he said, yes, he had called before, and he stood corrected. And he told you that there were calls back in November. Not true. Okay? There were previous calls, but they were the previous day, on February 3rd, the day that the account was open. 2 calls to that same banker, 12:15 and looks like about 2:50 p.m. 2 calls to that same banker, Jerome Bellin, at the time that Chase was opening, that he got the $100 to open up the bank account. Could that be the reason for the call? Then Mr. Imes talks about this, he talks about a so-called meeting. They poo-poo the idea that a meeting even occurred. And they shout it with convincing volume. Okay? But then they say the meeting couldn't have happened because Joseph is on the internet the entire time. His records show him on the internet the entire lunch time that this meeting supposedly is occurring, is what Mr. Imes indicated to you. Okay? But if you look at the records, there is internet activity. He's right about that. But if you look at the internet activity during that period from 1 o'clock to, between, 1 o'clock to almost 3 o'clock, okay, this is the internet activity he's referring to. Look at the amount of time that Joseph is actually on the internet. It's 0. It's all zeros. Does that mean his phone is registering data? He has an app open in his pocket? Or does it mean he's actually working on the internet and surfing the internet? It's 0, ladies and gentlemen. That's the time that he was on the internet. But yet it's represented to you that this meeting couldn't have occurred because Joseph was working on the internet. That is misleading. These are the calls that I spoke of earlier. They're shown on Joseph's records. These are the 7 calls that Joseph makes to Chase after the lunch meeting. They register on Joseph's cell phone records, and they register on Chase's cell phone records. And every single call is from Joseph to Chase. Then he tried to discredit the meeting by saying that Mr. Merritt contrived the idea that Joseph would have driven the trooper to the meeting. Because Joseph doesn't drive the trooper. Let's hear what he said.
I'm going to object once again. Council statements are not evidence.
Overruled.
There's one thing you must ask yourself. Does common sense tell you that in fact Joseph was the usual driver of the trooper? We may revisit this in a little bit, but think about it. You're married. You have a 4-year-old and a 3-year-old that sit in car seats. You have a wife who's very strong-willed, as everyone has testified to, and very opinionated. Is Joseph going to leave Summer at home with a car she can't transport those kids anywhere for over an hour or 2 hours or 3 hours? What husband in his right mind would do that? You never heard from Mike or Susan that in fact Joe was the usual driver of the trooper. You heard no such evidence. Again, you only heard that from the self-serving guilty conscience statement of the defendant from February 17th.
And from one other person.
They drove 2 vehicles. The green Dodge you see here in the driveway of the residence, the evidence will show was always parked there. And typically Summer drove that vehicle. The family also owns this white Isuzu trooper that Joseph primarily drove.
So, in the beginning of the case, they led us all to believe that Joseph drives the trooper. That was the evidence we were given.
Objection assumes facts not in evidence.
Overruled.
And you heard it in their opening statement. Yet, when it's a fact that to corroborate Mr. Merritt's statement, Mr. Imes, with convincing volume, with convincing authority, says the opposite. To discredit Mr. Merritt, to say Mr. Merritt is lying about having the meeting or having the opportunity to have this touch DNA in the trooper. February 8th, who drove the truck, the trooper, to San Ysidro? How did it get there on the 8th? That's a weird date. Where's the evidence of what happened on the 8th how did it get there? And I disagree with the prosecution on Dugall's thoroughness. Dugall could have easily got surveillance for days before and days after for all those shopping centers. He didn't get it. But he did get from 5 to 11, which tells us something. It tells us that at the time when Dugall investigated, when he was boots on the ground, he interviewed Murray, the security guard, who was on duty. And he told him, that trooper could not have been there before 5 p.m. because I was on duty.
That misstates the evidence. There is no evidence of that.
Mr. Murray's signature is on that form. And Dugall testified that that's why he got the security tapes from 5 to 11, because that's what he was told. That is the evidence, ladies and gentlemen. So, why then do we hear this?
It's during that time, ladies and gentlemen, that the trooper was noted at 9:18 p.m. in the San Ysidro parking lot by the security guards working for Bruce Carter. It is during that time, that long period of time, in which the tow was authorized at 9:19 and it was ultimately towed and closed out at 11:05 p.m. A lot of time on February 8th for the defendant to move evidence, clean evidence, hide evidence. All day long, really, except for the short time he's writing checks to himself to profit from the disappearance of Joseph McStay.
In order for Mr. Merritt to have driven the trooper to the San Ysidro border, Mr. Merritt would have had to have dropped it off by 11:30 at the very, very latest. Why? Because at 1:30-ish, he's on the 91 freeway traveling west in Corona, in the western part of Corona. And he then travels from 1:30-ish up, from that time up to Rancho Cucamonga area, and he's there for the rest. His phone pings the rest of that day in Rancho Cucamonga. So in order for the 8th to work in their timeline, he had to have dropped the car off at the San Ysidro border, the latest at 11:30, and then book it as fast as he could to get to the 91 at that time. Anything after 11:30, not possible.
Objection misstates the evidence.
And Mr. Imes' argument.
Overruled.
But there's a problem with that, because Carmen Garcia, remember her testimony? Mr. Merritt is at Metro Sheet Metal in the morning. And this question came from the judge. He asked the judge asked Carmen Garcia towards the end of her testimony, what part of the morning was Mr. Merritt there? And she indicated to the judge it was mid-morning on the 8th. So he couldn't have dropped it off mid-morning. And it's interesting. The people's theory then changes again. So now they bring in the other security guard, Jackson, who now says he was on duty. And it changes. It could have been dropped off at any time during that day. Like everything else in this case that the prosecution offered to you, and I mean everything, there's not one thing that they can throw at us that we weren't able to counteract. Including their business relationship. They wanted to suggest to you that they had a bad business relationship, that there was some type of problem between them. There's no evidence of that, but yet they argue it to you. Mr. Imes argued that there was some problem between them and he's looking to replace Mr. Merritt. It's utter nonsense. They were doing great together. They were going to do great things together. They were looking forward to 2010 to expand their business. Even they acknowledge that.
And we don't know, actually, what the status of their business relationship was on February 4th when the McStay family went missing. We know it was good prior to that. At some point, there was an email on January 1st that said, hey, Happy New Year, let's hope business is great. But at some point, something in there changed.
So even according to them, they have to acknowledge that January 1st communication between Joseph and Chase, where Joseph tells Chase, Happy New Year, we're looking forward to great things in 2010. You don't say that to somebody you're having problems with, somebody you're going to disassociate yourself with. But then she says something goes wrong. Well, what goes wrong? Nothing goes wrong. Things get better. They get the 2 deposits from Saudi Arabia and Paul Mitchell in January. Nothing went wrong. But they sold you on this idea that something went wrong, that they had a bad business relationship. It's not true. None of it's true. It's just barking and yelling. There's no substance to it whatsoever, but it sounds chilling. When the prosecution is using phrases like greed and theft and off the grid. You and I, when we go to bed, we put our phone next to us, or we go to a location where there's no reception, or we turn off our phones for whatever reason, or we run out of battery, like I frequently do. That's what happens in life. Not with Chase Merritt. He's off the grid. Off the grid, so he can go clean the killing mess in Fallbrook. More time. It's all nonsense, and there's no evidence of it. It's a story. Remember the easy part about saying who? I can point the finger at whoever. They're skilled lawyers. Surely they can do it and say, make up anything they want around it, and it sounds chilling. It sounds chilling when you say somebody's greedy and they're a thief and they're this and they're that. And we're going, yeah. And then you have a grieving family. We want to do something for that family. So we're receptive to those words, especially when they're barked out so loud and so convincingly. There's a missing laptop. You heard that from Brian LaRocque. He finds it through searching the database. They use the term, its name, if a computer can have a name, is Giuseppe Laptop. Okay? And the reason I put Exhibit 855C up is because that's that's Summers' laptop. And if you look at the last date of activity, and Brian LaRocque testified to this, of 10/25/09, that's the last time her laptop was ever used. Because the prosecution tried to make it seem like we were making this story up about that there's another laptop out there that's been not recovered. Okay. Well, Summers' laptop was never used after October 25th, 2009. But from Detective Schroeder and his analyzing the HP device number 5, finds these photographs are on the HP laptop, desktop computer in the McStay residence. And we see Joseph working on a laptop, and the date is October 28th, 2009. Now, Summers' laptop was not functioning and not being used after October 25th. So the laptop that Joseph is using there is his laptop. It's Giuseppe Lap. And when you go to the photograph of Summer on the right using a laptop, that's on January 15, 2010. Surely that wasn't her laptop. That was Giuseppe's laptop. And we know that Giuseppe's laptop was working and being active at this time period in January of 2010 because it's communicating. That's how Brian LaRocque finds it, because it's communicating with the desktops in the house. And you can see Giuseppe Lap here, Giuseppe Lap here. These are the individual, whatever computers do with each other. That's how it's identified. And you can see it's active up until February 3rd, 12:26 p.m. So what happened to this laptop? Where is it? What information is on that laptop? Does it have information about checks? Writing checks? What's on it? This is Exhibit 831. This is the SketchUp activity. I already talked about that. But Exhibit 831 also included the activity at 7:55 to 8:05, where the checks, where Intuit is accessed, QuickBooks Online is accessed, and the check alignment page is sent to the print spooler. And these are the exhibits that would verify those times from 7:55 to 8:05. And again, the question becomes, who would have been doing that at that time? It makes no sense that Chase would double back and do that. Exhibit 839 was on 2/4. We see that there was access at 6:08:57 p.m., almost 6:10. You have QuickBooks Online is accessed at that time as well. That is, even according to the prosecution, cannot be Chase. That would have to be Joseph's activity there. And I do want to talk about the allele lists that were generated by us. When I say us, meaning when we were working on this case, Mr. McGee and myself, we of course wanted to go and look at the evidence and see what we could develop. Okay, so one of the things we thought about is, let's go to the items that were in the gravesite. Let's do that, because after all, the prosecution and the investigators, the detectives, also did that. They looked at that evidence. In fact, you heard from Jones, Don Jones, that the investigators, including Detective Smith and Detective Bachman, they all wanted answers, and they wanted the items tested for DNA. Don Jones himself indicated that, based on the detective's insistence, he looked for items where he could potentially find DNA in the grave. And what did he come up with? He came up with the white cord, the straps, because these things had knots. Because that's where, if it's going to survive in the grave, it's going to be in these knots. And so that's what Don Jones did. Okay? Now the difference was, we noticed that, and you heard from Don Jones, he went to that same white cord, I think it was E15 was the item number, and he took out his equipment and he swabbed the knot area for DNA on the red cords and the white cord. Okay? Because that's where you would logically go to if you're looking at items in the grave. And Don Jones told you that. The best chance for him to find DNA on the items in the grave would be to go to those items that were hidden from the decomposition fluid that would surely destroy it. But he used outdated and antiquated methods that would make it almost impossible to generate any type of genetic material when you're using a little swab. But technology has advanced. And remember, Don Jones had been retired for 4 years. He's only a volunteer. So we went and we were able to get Susanna Ryan. And she is a DNA scientist. And she uses a new method, a modern method. It's not swabbing, it's an MVAC. And she did a demonstration for you. Because that doesn't just swab, it sucks. Okay, so if there's material, even microscopic material, there's a potential that you could get it if it wasn't destroyed by decomposition fluid. And that's what she did. She did a demonstration for all of you. Okay? So she was able to generate those samples, which were then sent to the lab. And that's what you heard from Bodhi Selmar. And lo and behold, ladies and gentlemen, we get a hit. When I say a hit, I mean we get DNA. Okay? The DNA had different compositions, different, it's not the ideal profile. If somebody were to draw blood from me, we're going to have a perfect thing, a perfect genetic sample to send to a lab to be tested because it's perfect. But solving crimes isn't always that easy. So, Bodie Miller has a threshold that they will test DNA on. And it doesn't meet that threshold. But that's okay, because they're a lab that relies on those thresholds. But you don't have to have a threshold. The modern DNA world passed thresholds years ago, a decade ago, in fact. Probabilistic genotyping is what is used, because many times you have molecular and microscopic portions of DNA that are analyzed on a routine basis, including this county. They use StarMix, which is another program. It's not True Allele. I guess they're competitors. Maybe who knows? But it's just the same stuff. And Dr. Perlin, whose credentials are unmatched by anyone in this industry, is able to generate these allele lists of allele that belong to an individual or individuals. He indicated 3. How did these individuals' genetic material get on the white cord and the bra strap found at the gravesite? How did that happen? They sure as heck went in at the time that they were buried. Whose DNA is on there? That's an unanswered question. The prosecution has had those allele lists for months and months. Dr. Perlin said it would take 1 to 3 minutes to do a single keyboard submission. Dr. Perlin put it into CODIS format for them. If it's all nonsense, then enter it. What's the
court's order?
What's
the problem? Prove us wrong. Say it's a bunch of nonsense. They even went to Dr. Perlin's, I think we heard testimony that Ms. Rodriguez and Mr. Doherty and maybe even Sergeant Smith flew to Pennsylvania to somehow find out something sinister about him, or whatever they went for, to read the source code, whatever. Because they knew that that's a problem. How are they going to deal with that? They chose apparently an effective way, which is ignore it and hope that you will too. Don Jones had, as I indicated, he looked for knots. That was his testimony. He looked for items that had knots. And guess what? He went to the same stuff we went to, which are these ropes that are tied up in knots and the white cord. Oops.
One of the items that excited me is analyzed way or discussed people from that white cord. The white cord is wrapped around the body of the decomposing, as you see here in this photograph. Would you expect that the individual whose body was there in the ground would have that individual DNA would be on it?
Probably not if it's part of the cord that had been exposed to the body. Yes, if the cord had been tied up and there was DNA on part of the cord that didn't come in contact with the body, whether it was from that individual or some other individual, then it wouldn't be exposed. And so there would still be, or could still be, DNA.
Oops.
Sorry. I was trying to see if I can play it.
No, it's okay.
There's nothing to play.
This is the same thing that Don Jones did in questioning from Mr. Doherty. Let's see where we're at. Let's see. Here it's starting at line 13. Why did you pick an area of knotting to swab? Answer. It was under the idea that perhaps if there was some sort of touch or trace DNA present, maybe the knot area would have protected it from the degradation that I felt took place through the entire gravesite. For me, it was not a very viable hope, but it was something to do in response to the request that was made to look for some sort of perhaps trace DNA that was present. Honestly, I had no hope of finding any DNA in any of these samples. We know that Don Jones didn't have much hope in it. Of course, when you're swabbing, I mean, come on. But if you use modern technology, perhaps you could. And we did. This wasn't some fantasy that they tried to make you believe. This was actual. And by the way, Susanna Ryan, Bodhi Selmark, and Dr. Perlin, these are the best of the best in this industry. The best of the best. It's hard for me to say these things to you, and it's hard for you to listen to me, I can tell. Some of you have already tuned me out, and that's okay. Because I understand that you don't want to hear this. Your vote basically sealed Mr. Merritt's fate. It's done. He will spend the rest of his life and most likely die in prison, either by lethal injection or by natural causes. But that doesn't mean we have to agree with it. And that's what the concept of lingering doubt is about. At the end of this, you've seen these clips of the prosecutors. There's tons of me. You know why? Because it's all, this trial was published and I guess not on TV, but on the internet, on gavel to gavel. You can actually watch it This is going to be probably the first time a jury can then, in a death penalty case, have coverage from gavel to gavel. If I've told you anything that is untrue, you'll find out. Because when you're free from the restrictions of the trial, you can go and watch it. You can not only see, you're not only going to be able to see the trial, but you're going to see the motions, everything that you guys had to wait outside for, you're going to see it all. It's all on the internet, every day. And you're going to see what I'm telling you is true. You're going to see that these prosecutors sold you a bill of goods. You're going to see that this family is not getting justice. Now, as a group, and this is in no way insulting to you. It's human nature. I can't say I would do anything different, to be honest. But as a group deciding on it, especially when you respect one another, it's hard to tell your fellow juror, no, that's not right. But when maybe it'll be a month from now or 2 months from now, maybe a year, at some point you will reflect on this. And maybe you will watch that gavel-to-gavel coverage, and you'll say, there was no evidence. There was a lot of barking and a lot of screaming and a lot of shouting, but there was no evidence. And by no means am I trying to disrespect you, as was suggested earlier. It's completely consistent in our system for me to disagree with you. That's okay. It doesn't mean, as I said before, that I don't respect you and respect your work, but I can disagree, and I do. The evidence in this case is what we gave you. We're the ones who went and did work and got things done and showed you what the real situation was. In retrospect, the prosecution's case is nothing. It's barking and screaming. And there's no substance to it. And all the timelines go away. Because they can tell you, they even said, they don't have to prove the where, the how, and the when. But you got character assassination. You got gambling, greed, checks, backdate, QuickBooks, blah, blah, blah. And whatever they said to you, with no exaggeration, whatever they said to you about QuickBooks was either taken out of context or unimportant and irrelevant. Why? Because there was never a theft. Ever. So, being the realist that I am, I understand that many of you have tuned me out and will continue to tune me out, and that's okay. Because I know there's a few of you who understand what I'm saying and agree with at least the premise that you may have been sold a bill of goods. Because you have. And you don't know it now because you can't have access to anything. You will know it soon. But to those few of you, you don't have to share your verdict with anyone. You can go and vote. You can go and vote with the confidence that you don't have to answer to anyone. No one has to know what your vote is. You can just go do it. There's no need to deliberate. There's no need to do anything except go in there and give your vote. And that's it.
Objection. That's improper argument asking the jury to disregard its duty.
Sustained.
Mr. Merritt is entitled to, and the law says that he's entitled to, and the judge read you an instruction that said that Mr. Merritt is entitled to your individual opinion. Thank you.
We'll take our morning recess at this time, about 15 minutes. Keep in mind the admonitions previously given to you, not to form or express any opinions about the case, not to discuss the case, and we'll see everyone back in about 15 minutes.